Hello, everybody, and welcome to the Western Land Policy Center Dojo. And I'm here with Dave Erlanson again, and we have a heck of a show for you guys today. We are going to talk about some serious subject matter, partially, mostly laid out in my book, which is now finished being edited, by the way. And within the next couple weeks, I will be going into probably a self-publishing situation, probably Amazon, something like that. But anyway, I've got Dave Erlanson with me, and we're going to get into some pretty deep subject matter today. What we're going to be talking about today, we're going to go back to the beginning. We're going to walk everybody through basically the foundation of the book. And I'm going to kick this off to Dave. Welcome, Dave, for, I guess this is round 3. This is our 3rd or 4th video. I'm unsure. We've done a few of them.
Yeah.
I'm going to kick this off to you, Dave. Why don't you launch this thing? We could get a little bit into the conversation that you and I was having on the phone about how we were going to structure this interview. And let's just start from the beginning. I have some things up on the board here. And this is kind of the format that Dave and I have decided that we want to use. And we're going to start with the Articles of Confederation, because that kicks off this entire Western Lands issue. And Dave, why don't you take it from there and just launch into this and take us on a ride here, buddy.
Well, okay. Everybody knows about my case with the EPA. And I've had inklings, and I've read Supreme Court cases and appellate court cases and circuit court, all these cases. And every once in a while, I get this little glimmer of, is the Clean Water Act a constitutional act? So I've been researching, and I finally decided you got to go back to the beginning, because in our last segment, we brought up Polar-Lisi versus Hagen in 1845. And we talked about that. And we talked about that there's nothing in the Constitution that gives Congress the authority under the dealing with the submerged lands. But I was interested in water because, well, you know, suction dredging and mining, you need water. And although the water rights have been allocated through mining, the 1866 mining grant for water and the right to ditch and make canals for mining purposes and milling purposes, I wasn't satisfied. And then, of course, the 1897 Organic Act says in section 16, let's see, yeah, Title 16, Federal Code of Regulations there at 481 gives, again, the miners the use of the water. And then, of course, we know that the Submerged Land Act was in 1953, and that gave the states the right to the Submerged Land Act, but it didn't give them, it actually didn't give it to them. It says, we recognize through this act that the states have the right to the submerged lands. And then, of course, culminating in 1955, where every unpatented mining claim west of the 98th meridian, the states have control of that. So what I'm trying to do is figure out, is there a split estate here? Is it all state controlled, or is it federal control? So I went back, all the way back, and I found the Articles of Confederation here, right here. I'm hoping you can see it, Ron.
Yep.
And that it's very important for the people to understand that this was the first Constitution for the United States of America.
Well, Dave, let me interrupt you right there, because this is going to come as a shock and as a first appearance, a first time hearing this to many people. And as you and I both know, when we have been putting, because look, we've been working on this problem for many years now. And we've highlighted the problem. I think to a large degree, we've highlighted the problem. So we don't need to keep going back to the problem. If anybody is curious about what we mean by the problem, you go back to the previous videos and look at the presentations in those videos. We can't keep going back to that. We got to start with where we're at right now. But in highlighting this problem, one of the things one of many things that has arisen is who has authority where to do what? How was the authority given? What was Congress's intention when they received the lands? Did they mention the waters? All these things. So in order to lay out the legal bibliography on this subject matter, Dave has realized, and I've realized, we had to go to the very beginning, which is the Articles of Confederation. And when you do that, you invariably run into some language between the Articles and the Constitution that lead you to believe that there are provisions of the Articles of Confederation that may still be relevant today. Dave, why don't you take it from there, and let's just kind of explain this a little bit to the people.
Okay. Well, as I said, I'll read right from the text here. It says, this first Constitution of the United States established a league of friendship for the 13 sovereign and independent states. Those sovereign and independent states, of course, are the 13 original colonies. And then it says, continuing on here, it'll say, each state retained every power, which is not by this confederation expressly delegated to the United States. That is of supreme importance, which is not by this confederation expressly delegated to the United States. So that, common terms, that means if it's not in this document and the powers aren't given, the enumerated powers aren't given to the United States, the Congress of the United States doesn't have it.
And why is that, Dave? Is like in the water situation, when we're talking about expressly expressed, that's something that's written, something that's stated, some sort of authoritative record of the water, right? Because that's really what we're talking about right now. This is really a water thing. I think we've dealt with the soil aspect of this. We're gonna bring that up. Dave's gonna highlight the soil water thing, but we're talking about expression now, and it says it very clearly in these documents, right?
Well, it can't get any clearer. Look, if it's not in here, the Congress of the United States has no authority to act upon something that is not in the Articles of Confederation. That is our first Constitution, folks. I know we were taught about our Constitution and the Bill of Rights. This is the first Constitution of the United States of America, right here, the Articles of Confederation. Remember the date, 1787. And there's something else I want to tell you about dates. Write them down if you're listening. And I'm going to read this right off the top here. The Articles of Confederation were adopted by the Continental Congress on November 15th, 1777. This document served as the United States' first Constitution. So there's no ambiguity. This is straight out right here on the document. Okay. It was enforced. This is very, 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 very important. It was enforced from March 1st, 1781 until 1789. Write those dates down, because in our future discussions here, we're going to highlight some things, and we're going to show you some stuff that's almost unbelievable, but it's in writing. It's in here. So, but 1781, 1789, when the present day Constitution went into effect. So until the present day Constitution that we have, this one right here, you know, the little book, till that came into effect, our government was run by the first Constitution. The first Constitution, instead of being called the Constitution of the United States of America, was called the Articles of Confederation. So we should all understand that right now. Now, in dealing with the water, we already said that anything in here, I'll continue through this, but it says each state, and I'm trying to prove that Idaho has the unequivocal, predominant role in water rights. And so Article 2 of this Constitution states, each state retains its sovereignty, freedom and independence, and every power, jurisdiction and right, which is not by this Confederation expressly delegated to the United States in the Congress hereby assembled. So if it's not in here, folks, Congress doesn't have authority to make laws, rules, regulations, statutes, or any type of mitigation rules to effectuate a change that is not located in this document. We'll go down to Article 4. I'm just going to go through where I have it highlighted. It says that the free inhabitants of each of these states and future states shall be entitled, it's very, very interesting, to all privileges and immunities of free citizens in several states. And Ron and I've talked a little bit about it in past videos. And the people of each state shall have free ingress and egress, regress to and from any other state, and shall enjoy all the privileges of trade and commerce, subject to the same duties, impositions, restrictions of inhabitants there respectively. Okay, here we see the word commerce and we see the word trade, but nowhere is the 5-letter word W-A-T-E-R mentioned in the Articles of Confederation. The word water. Water is the United States, water are the territories. However, no mention of water in the Articles of Confederation. That is of supreme importance. This is, I don't know, it's probably a 25-page document. I read it 10 times this morning. Here's a little interesting caveat. In studying the water issue, and this has been back 3 or 4 years ago, Ron and I discovered this court case, Kansas versus Colorado. It deals with the Colorado River, the state of Colorado irrigating their fields and leaving hardly no water in the Colorado River for Kansas to do likewise. So they took it to the Supreme Court. But lo and behold, in the Articles of Confederation, it states, and I need to read this because it's very interesting. The United States in Congress assembled shall also be the last resort on appeal in any disputes and differences now subsisting or that hereafter may arise between 2 or more states concerning any boundaries, jurisdiction, or any other causes whatsoever, which authority shall always be exercised in the manner following, whenever the legislative or executive authority or lawful agent of any state in controversy with any other state shall present a petition to Congress, stating the matter in question and praying for a hearing. Notice thereof shall be given by order of the Congress. And then it goes through all the commissions, the appointments that Congress makes to adjudicate this case. Doesn't mention anything here about taking this case to the Supreme Court. I was shocked when I read that. Um, here's a good one here dealing with the boundaries. All controversies concerning the private right of soils claimed under different grants by 2 or more states, whose jurisdiction as they may respect such lands, and the states which pass such grants are adjusted. The said grants, or either of them being at the same time claimed to have original antecedent to such settlement of jurisdiction, shall, on the petition of either party, go to the Congress of the United States to be finally determined.
Yeah, so everything points to the fact that the Supreme Court in the land settlement in the settlement program, the court, the federal judiciary, was never given the authority to decide on any sort of boundary conditions between the parties or on private rights matters between the parties that would have to be resolved by Congress. Is that what you're saying?
Yeah, that's pretty much what I'm saying. Yeah.
Although it does say in the Articles of Confederation that the privileges and immunities of all the citizens should be maintained in all the properties. And
that's correct.
Okay, so this is very interesting because we've already highlighted the fact that in the territories, the way that Congress views the territories is a systemic deprivation of not just private rights, but the privileges and immunities of the citizens and the private rights of those citizens regarding land matters for like mining claims and things like this. Yes?
Yes. Yeah, I agree with you 100% there in that statement. There's no question about it. You're right. There's no question. You want to hear another little interesting tidbit? Yeah. Remember, this is 1777. This is 12 years before the present Declaration of Independence Constitution of the United States, our present one. This is the original Constitution. Look it up. Look this up, folks. Look it up. Article 11. Canada, acceding to this confederation and joining in the measures of the United States, shall be admitted into and entitled to all the advantages of this union. But no other colony shall be admitted into the same unless such admission be agreed to by at least 9 states. 9 of the 13.
Yeah.
Now, isn't that interesting? I never knew that Canada was a territory of the United States. Did you?
Well, I think they were given an option to be that. I just don't. What we would need to find is some sort of documentation that showed that actually happened. And
well, see,
it should be in the congressional record.
Right, but what gets me is it says, and joining in the measures of the United States shall be admitted into and entitled to all advantages of this union. It says to me that it's been admitted into and entitled to all the advantages of the union, but then it goes on and says no other colony. So it sounds to me like they thought that was a territorial property or a colony of the United States at that time, which I can't find where it's ever. I found in 1867 where the sovereignty of Canada, because of 3, I read it today, 3 provinces decided to go under British rule, and then the rest of them followed suit. I think the last one to follow suit, if I'm not mistaken, was British Columbia. But anyhow, that's a Canadian thing. I thought that was interesting to bring it up in there. Let's see, is there anything else in here? As I said before, the timeline is what you have to keep in mind. I will read, it only take me a second here, Article 13. Every state shall abide by the determinations of the United States in Congress assembled on all questions which by this confederation are submitted to them. And the articles of this confederation shall be inviolably observed by every state and the Union shall be perpetual. Nor shall any alteration at any time hereafter be made in any of them, unless such alteration be agreed to in a Congress of the United States and be afterwards confirmed by the legislature of all states. That's a huge statement, because that means you can't alter this document unless all the states, including the Congress, but all the states have to agree to it. That's pretty that's pretty paramount there. I mean, that's really
it is, because because we know that alterations have occurred, and we know that those alterations have occurred without the consent of all the states. So it's a big deal.
It's a huge deal. It's a huge deal. Now, as you were mentioning, let's remember the timeline. 1781, 1789. Okay, so we have the Continental Congress. Things are going along. They start working on the Constitution as we know it in the little book right here. They start working on that. All of a sudden, for land disposal, they come up with what's called the Northwest Ordinance. And this Northwest Ordinance, I know the date because it's July 13th. I was born on that day. 1787. Of course, I'm not that old. But anyhow, what it says is, it says Congress assembled. This is a congressional action. It is not the Articles of Confederation. It is not a constitution. This is a law. This is a land disposal law. When you read this, remember the date, 1787. Remember the date of the Article of Confederation, 1789. The Articles of Confederation, this is the point I talked to Ron about earlier on the phone. When they made the Northwest Ordinance to dispose of the land and made all the rules and regulations in here, this document, the first Constitution of the United States, was still in force, folks.
That's right.
So any changes to that document would have to be ratified by all the states, would have to be ratified by Congress, and an amendment to the Constitution would have to be done.
That's right.
Okay, so we got that. So now let's go to the Northwest Ordinance. And it says, according to the ordinance for the government of the territory of the United States, northwest of the River Ohio, was read for a third time and passed as follows. To me, and I'm talking about sovereignty, jurisdiction over the water, it's very interesting that they do not include the Ohio River in the Northwest Ordinance because it's water. They say west of the riverbank. They don't. They leave the river out. Now that's an interesting caveat right there. And then it goes to be it ordained by the United States and Congress assembled that this said territory purposes of a temporary government be one district, subject, however, to be divided into two districts. And I read in here someplace where they could have military and all that. But I want to keep going on here. The next page. Well, they're talking about how many. We'll leave it go. They talk about how many male inhabitants and all this stuff to make a state out of a territory. They talk about the governor and judges. They talk about a court being appointed in 3 judges to form that court.
Dave, let's stop right there. Okay, so you have this Northwest Ordinance document, and inside this document, which is a law passed by Congress, they create a judiciary.
Which wasn't in the other one that I could read.
Yeah, so this is a territorial judiciary, yeah?
That's right. Yes, it's territorial courts.
What, explain to the people what is so significant about the creation of these territorial courts?
Well,
Why
significant.
do they call them legislative courts in the documents?
Uh,
Because they're under the tutelage of Congress. Directly.
well, I understand that, but this is way back before I started doing a lot of this. I just got into this 2 days ago. But the deal is that the territorial courts today, because of the territorial properties in the Western United States still exist, I would venture to say 99% of the courts are territorial legislative courts today in the Western United States for sure. I'm not sure about the Eastern United States, Ron, because there's very little territorial property in the Eastern United States. The land disposal system under this document basically disposed of all the land to private ownership. But once you got west of the Louisiana Purchase, which would be the northwestern tip of Montana, and a fairly fairly ununiform line. I think it follows the Missouri River down through. The states west of that, because there are so much public lands, public trust lands, national parks, national recreation areas, the state of these, Idaho, Utah, you name it, these states west of that huge land purchase, the Louisiana Purchase, those courts are successors. The district and state courts are successors of the territorial courts in all aspects. And when you want to look at that, all you have to do is look at the Idaho Admissions Act. I think it starts in section
17.
50, well, it goes 15, 16, 17, and 18, I think.
Yeah. Yeah,
It goes,
they really get into the meat of the successor. They talk about the successor of the courts.
yeah, I think it's in 17. Yeah.
Section 17, yeah.
Yeah. They begin talking about jurisdiction in the Ninth Circuit in I think it's 15. It might be 16, but anyhow, yeah, they go through that, and because of the amount of the territorial properties in Western United States, those territorial courts, and where most people are taken, if they aren't taken to a administrative state judiciary, in other words, administrative agencies, judicial tribunal or court, you're in my opinion, you're in territorial court when you look at the Idaho Admissions Act. I think that pretty much sums it up there. I really do. Now I realize that California and Texas were not territories. They went straight from having their boundaries put in place and surveyed straight into statehood. They did not become a territory first, those two states. And so I don't know how the laws affect
the Admission Act of California. In the Admission Act of California, the residents of the state of California agreed to turn the land over. You're right. They didn't create an organic act, so they didn't. That was the whole thing about territorial. If they created an organic act, Congress was taking possession of the land. But never happened in California. So California has some negotiating power here.
Yeah.
With the federal government. If they really wanted to, they could have pressed the issue big time, but they just allowed the federal government to say, well, we are making a claim. The federal government said, we're making a claim against all the land that's unappropriated And in order to admit you into the union, you're
You
going to
have to give it up.
got to give it up.
That's exactly the deal. Now, and because I've got a copy of the California admissions, and I've been trying to look at these, and so I knew that was the case. I haven't got into Texas yet, so I don't know anything about it, so I can't comment. But anyhow, getting back to this Northwest Ordinance, I think what we need to do is get into the meat of this. I don't want to prolong this video any longer. I want to do these couple things here and then let you look these things up on your own and study them, just like Ron and I do. On page 339 of the actual July 13th, 1787 congressional report here, which is the the land disposal here, it says right down here, it says, and for extending the fundamental principles of civil and religious liberty, which form the basis whereon these republics, I got a kick out of that, these republics, their laws and their constitutions are erected, to fix and establish those principles as the basis for all the laws, constitutions, and governments which forever hereafter shall be formed in the territory, to provide also for the establishments of states, permanent government therein, and for their admissions to a share in the federal councils on an equal footing with the original states. And that pretty much coincides with the equal footing doctrine that all the states are supposed to be, at the beginning of your territorial deal, your territorial legislature applies for admission, and they always ask to be put on an equal footing doctrine. And when I started looking into this, I thought, well, how could we be on an equal footing doctrine? Idaho, when 63% of the ground is federally owned, and you look at, Pennsylvania, New York, Virginia, and 2 or 3% of the ground. And I thought, that's not equal footing. There's something drastically wrong here. But after I looked at the equal footing doctrine and what it actually meant in the constitutional law terminology, however you want to say it, it only means that the states, the territories that become states on an equal footing, they have a representative form of government. That's all it means. So I learned something there the hard way, because it took me about 2 years to finally figure that out and read the right documentation. But anyhow, I thought that was pretty interesting. Then we start really getting into something here on page 340. And I was really excited to see this because it's something in my court case I didn't have the opportunity to do. But the second article, the inhabitants of said territory, and I took a real interest in this, the inhabitants of the said territory. They're talking territory here. Shall always be entitled to the benefits of a writ of habeas corpus and trial by jury.
Ooh.
In the territories.
Ooh.
And one of the reasons that Ron and I thought there was a administrative deprivation of rights in my case was because the Environmental Protection Agency thought I was on the territorial properties of the United States because I was within the Nez Perce National Forest in 2015. But when I saw that, where it said the inhabitants of said territory shall be entitled to the benefit, and then trial by jury, I couldn't believe it. Because that means that the EPA deprivation of rights in my case had no jurisdictional basis to deprive me of my rights. There's no question now. Because I know that the EPA has no authority over the submerged lands nor the waters of the United States. They don't have any authority. I'm sorry. And the Clean Water Act is an unconstitutional action, which we're going to prove here. Okay, so anyhow, well, we already did, because it's the word water is not mentioned in this Constitution. And we're going to go to this Constitution. And we're going to see if the word water is in there. But for now, we're going to go with our land disposal, the Northwest Ordinance. Remember the date, 1787.
Hey, Dave, before you go any further, I just want to let the people know why what Dave said is so important. Because if it's not mentioned in the Articles of Confederation and it's not mentioned in the Constitution, where are we, Dave? What authority do they have to apply things outside of a lack of enumeration of the Constitution to the object?
Well, it's obvious, Ron. Congress can only operate on the enumerated powers. If it ain't listed, they don't have the powers. Now, they can say they have needful rules and regulations. That's fine. And they can regulate commerce, and that's fine. But to make the stretch that because the water goes from Idaho to Montana or vice versa, and so that we can control the navigable waters of the United States, is an incorrect and unconstitutional assumption, because it's not in the Constitution. If the waters aren't in there.
And it's not in the Articles of Confederation either.
That's right. And the Articles of Confederation were never amended. Those Articles of Confederation were incorporated in the basis for the Constitution we know of today, right here.
Yep.
That's it. Okay, so let's continue on with the Northwest. Like I said, we're getting into some good stuff here. Okay. They mentioned a little bit about the Eighth Amendment. All fines shall be moderate, and no cruel or unusual punishment shall be inflicted. That's basically in your Bill of Rights and as the Eighth Amendment. And then they say, no man shall be deprived of his liberty or his property, but by the judgment of his peers or the law of the land. Which means when EPA fined me and took part of my Social Security check to pay for it, there was no judgment of my peers. They acted unconstitutionally, my friend.
They did not give you the option of a jury trial, and they were compelled by both constitutions to do so. There is literally nothing in our historical documents to allow these people to deprive you of a trial by jury. And
That's
yet
right.
They're doing it.
Every day. Not just to me, to hundreds and hundreds and hundreds of Americans, and in the course of years, thousands of Americans, and most Americans don't know their constitutional rights, don't want to hire a lawyer, so they say, well, yeah, I'm guilty, I'll pay the fine. It's a scam. It's a scam, and it impairs and deprives you of your constitutional rights.
And this is eroding constitutional government, is it not?
No argument here. No argument here. Okay, so let's keep going down here. They talk a little bit here about eminent domain and the preservation of rights and property. It says it's understood and declared. I love this little part here. I have to read it. That no law. This is what it says, folks. I'm reading it right out of the Northwest Ordinance. That no law shall be made or have force in the said territory that shall in any manner whatever interfere with or affect private contracts or any engagements bona fide and without fraud previously formed. What does that say? That means that in this document, They're saying that you can't make a law to impair a contract or an engagement with another party. Now, what I don't mean engaged to get married. I'm talking here about contracts between corporations, between people, between.
Let's highlight a scenario here for people so they understand what you're saying here. Let's say you got a rancher. He has the legal right to ranch on federal land. He's paid the fee. He's done all the permitting. Everything's good to go, and he's ranching. And this will tie into the Bundy situation that happened in Arizona. So he's ranching, and he's got contracts with people for the sale of cattle, for slaughterhouses, for whatever. He's got contracts. So when the federal government comes in and interferes with the operation of that rancher and the expression of that rancher's fulfillment of the contract that he has, they are in defiance of their own law.
Exactly. Now let me take that one step further. Let's say the Bundy, let's call this entity the Bundy Ranch, had grazing rights on the federal estate. Let's say a miner has a federal mining claim. That means that you have a contract with the federal government. You pay them a fee to have the privilege to use their public domain. This says that if that is enforced and you're doing things properly, an entity of the government cannot come in. Let's say they have a federal grazing permit. We'll take that as first example. They have a federal grazing permit. The government can't come in, the Bureau of Land Management, and say, hey, you got 5,000 head of beef on this grazing permit. You're done. You're done. We're taking the grazing permit away from you. But I paid for it, Bureau of Land Management. I paid for it. I have a 3-year lease here. No, we're done. You're done. What am I going to do with all? I got to sell everything in the lots. You're putting me out of. This is what they're talking about.
Yeah.
Take the federal mining. Take the claim owner, the federal mining claim owner. He's up on the Nez Perce National Forest. He's mining. He's trying to make a living. He's done everything right. Okay. His mining is less than 5 acres, so he doesn't need a plan of operations. He doesn't need this stuff, even though the forest pushes this stuff. The U.S. Forest Service pushes this stuff. The actual rules in the Bureau of Land Management, who oversees federal mining claims, says 5 acres or less, not a significant disturbance. You don't have to do all this stuff. But anyhow, they come in and say, you're shut down. You got 2 days to get your equipment out of here. That's what they're talking about. Now, the person who's processing the ore, he's out of business. His workers are out of business. The people that were counting on the ore to sell or make product out of, now they have to find a new supplier. That's what they're talking about in this stipulation. And so I think that's really important to highlight in this land disposal deal. Okay, let's see here. Let's continue on. Now we're really going to get into what I like. The fourth article. I can't believe it.
I know, this is a good one.
This is it. Now this is it. This is where the proof that the Clean Water Act is an unconstitutional action. You heard me right, folks. This is the proof. Article the 4th, it's called. Page 341, July 13th, 1787. The said territory and the states which may be formed therein shall forever remain part of the Confederacy of the United States of America. Here it is, folks. Subject to the Articles of Confederation.
Whoa, 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 whoa. Can you read that for the people again, please?
This is huge. This is absolutely phenomenally huge. Article the 4th, July 13th, 1787, Congressional Record here, for page 341. The said territory and the states which may be formed therein shall forever remain a part of the Confederacy of the United States of America. Subject, here it is, this is it, subject to the Articles of Confederation.
Okay, let's stop right there.
You got it.
We're going to explain this to the people in a very simplistic way.
Okay.
The Articles of Confederation was the first Constitution. The Constitution of the United States was the second Constitution. If the second Constitution doesn't change any
Verbiage
of the first Constitution, that means the provisions in the first Constitution are still in effect according to what you just read. Right?
Guaranteed. Guaranteed. They are in effect. Yes. And remember the dates. Remember I told you, write down the dates right here, Articles of Confederation. Valid from 1781 through 1789 until our present day Constitution went into effect. This was done 2 years previous, 1787. Okay, so I'm going to read that one more time because it's so important. The said territory and the states which may be formed therein shall forever remain part of the Confederacy of the United States, subject to the Articles of Confederation, and to such alterations therein as shall be constitutionally made.
Let's stop right there. Okay.
What Constitution are they talking about here?
The second one.
That's right.
Second one. Because the first one, while it was a Constitution, they didn't really consider it a Constitution. But when they made the other one, it was okay. So here's the way this whole thing is supposed to be laid out. The first Constitution,
Articles of Confederation.
Articles of Confederation wasn't really a Constitution, but the second Constitution, when they created it, the lands provision was done under the first Constitution. So the lands were placed underneath it.
That's right.
Underneath it.
And the waters were exempted.
Were exempted. They never talked about the water in the first one, and it never comes up in the second one.
That's right. So here we go. What I like here, and to such alterations therein as shall be constitutionally made. Now, they just said the Confederate, everything relies on the Articles of Confederation, and then anything that changes must be constitutionally made. So what you said, Ron.
One second. That means that Congress at any time can pass a constitutional measure to make a change in their properties because the properties are underneath the Articles of Confederation, and the provisions of the Articles of Confederation that the Constitution has not changed are still in effect.
That's true. That's true. And the only way that they can do this, the only way the Clean Water Act is legal, is to make an amendment to the Constitution of the United States. That's the only way. This expansive power under FDR that we're experiencing today with all these agencies and these hundreds of thousands of government employees is all unconstitutional. I hate to say it, but it's true. It's true. It's right here. And when we get into this, I'll prove it. Because this is the new one. But let's finish up the Northwest Ordinance here real quick. the legislatures of those districts or new states shall never interfere. Listen. Shall never interfere with the primary disposal of the soil by the United States and Congress Assembly.
Whoa. You left out a very important thing. You didn't say anything about the water, Dave.
Well, hold on. There's nothing mentioned about the water yet, but I'm going to tell you what's going on here. Okay. Sure, we're talking about the land. Nor with any regulations Congress may find necessary for securing the titles of such soil in a bona fide purchase. So in other words, just a good example was the grazing rights.
Yep.
The mining rights. Miners pay to get a right to mine their material. The rancher pays for his grazing allotment up on the forest or the BLM. So that's talking about that, but that's all land-based.
I got to stop you right here because I'm going to bring something up that's vitally important to everybody watching this, to this exercise and this discussion. Dave, you and I have both read FLIPMA. One of the things that attorneys today are going to tell you is, everything's under FLIPMA, so all that old stuff is all by the wayside. I'm asking you, is there anything in FLIPMA? Is there anything in the 1955 Multiple Use Act that alters the original arrangement under the Articles of Confederation or the Northwest Ordinance or the Constitution on this matter? Is there?
Specify which matter you're talking about, water or land?
Primary disposal of the soil. Is there anything in FLIPMA that alters the authority that was created? Okay, let's stop for a moment. All right.
That's a big, FLIPMA is a big land. I mean,
we know that the lands program, there's only one piece of legislation that started the lands program. It was the Northwest Ordinance. The Northwest Ordinance was Congress's starting of its lands program. Since then, all they've done is create legislation that alters policy. The original authority.
That's true.
The original authority for disposal of the soil came from the Northwest Ordinance.
That's true. Yes.
That authority and the disposal of the soil, the intention of Congress to dispose of the soil, has that ever been altered by the Multiple Use Act or FLIPMA?
Well, it hasn't been altered by the Multiple Use Act. FLIPMA, well, it hasn't been it's been watered down a little bit in FLIPMA, dealing with federal mining claims and in the designation of any mining claims versus locatable mining claims. But the deal is that the way that's stated in there, I'm sorry to say, FLIPMA is legislation, and it's done by Congress, and I understand that. And the Northwest Ordinance is also legislation. It's not a constitution, it's legislation. But it did put out a land disposal program for the territorial properties of the United States, and that program went all the way through the Louisiana Purchase, the Ohio territories, went all the way through. But then when it got to the 11 Western states, they disregarded the Northwest Ordinance, and they said, we're not going to follow it anymore. Where that stipulation came from in Congress, where that act of Congress came in, to where they all of a sudden decided we're going to hold all the property in territorial property ownership for the United States. We're only going to give the states what they need for a few political subdivisions, for schools, universities, for agriculture. The rest of it we're going to keep. And so I have yet to find the authority that disposes of the Northwest Ordinance. I can't find it.
It was.
I mean, I'm not saying, look, Ron, I'm not saying it ain't there. But I look and look and look and look, and I can't find it.
Dave, I spent 12 years digging this information up, and I never once found any legislation passed by Congress that altered the land program in any way, shape, or form. You're right. They were playing it loose. They were playing it off the hip. They were doing what they wanted, and they had no authority to create states in the Western United States, and they did it anyway.
That's right. Exactly right. I agree with you 100% there. Okay, Ron, now to finish up this Northwest Ordinance, we've discussed this property deal. This is, to me, this is the biggest historical collaborative effort on the part of bad actors, some of which were in the Constitutional Congress. Because this next paragraph, couple sentences, proves it. Let me go back and say one quick time. I don't want to keep going back too much. Remember the dates, the 1789. This is the law of the land. This is the Constitution of the United States at that time. It's called not the Constitution of the United States. It's called the Articles of Confederation. Here comes the land disposal mechanism. Okay, the Northwest Ordinance, July 13th, 1787. 2 years, this is still in effect. This is still in effect. Articles of Confederation still in effect. Here's Congress. Remember, Congress did this. Congress wrote this. This is a law. It's a land disposal law. It says, and I quote, the navigable waters leading into the Mississippi and St. Lawrence rivers and the carrying places between the same shall be common highways and forever free, as well as to the inhabitants of said territory, the citizens of the United States, and those of any other state that may be admitted into the Confederacy without any tax, impost, duty therefor. This was a unlawful, unconstitutional usurpation of power by the Continental Congress, because they mentioned navigable waters. And then when they wrote this, they were writing the Constitution at this time. When they wrote this, they mentioned commerce in this one, but they forgot to mention water. So they mentioned the water there, navigable waters. And through the course of history, from our founding documents, when it came up to the Environmental Protection Agency, they took that statement of the navigable waters of the Mississippi and St. Lawrence River, and they took this one here, where they said they could regulate commerce, and they stuck them together and said, we have authority over the navigable waters. That's too much of a stretch. It's not constitutional. Because why is it not constitutional? I'm going to explain real quick. It only take me 2 seconds. Because this is a law passed by Congress, the Northwest Ordinance. This is a constitution. For this, for them to put something in here that was not enumerated in here is an unconstitutional action, and in 1803, under Marbury versus Madison, it's null and void. And that's just the way it goes, folks. This water deal here, that doesn't mean, I can't say that. It doesn't mean much to me. Because This is the founding document right here, Articles of Confederation. And it tells you right there, the states, if it's not enumerated in here, the states retain full jurisdiction and authority. Therefore, it's my contention, the EPA, under the Clean Water Act, has no enforcement in any state in the United States, let alone they gave up the right in any mining claim in the 1955 Multiple Use Act, westward of the 98th meridian. So there's no question. So if the EPA and if their attorneys could convince the Supreme Court of the United States that what I'm saying is wrong, and I don't think they can, I really don't. I mean, it's right here in writing. I don't know. You can argue, but you can't argue unambiguous language. It's right here. I'm sorry, it's right there. And so, but if they were to do that, the 1955 Multiple Use Act says that the state has 100%, 1000% jurisdiction over the use, control, and appropriation of any waters in any unpatented mining claims. Congress, if they say, well, Congress had the authority to do this, then they had the authority to give all the states westward of the 98th meridian on their unpatented mining claim, they gave up their right to the water.
Well, that's like saying that Congress had some sort of unknown and unfindable authority via some unknown and unfindable legislation that has never been passed, as far as I could tell, to alter the parameters of the Northwest Ordinance land settlement program and do something totally different in the 11 Western states than they did in the original Northwest Ordinance.
Yes, if you're talking about the land, you're 100% right. On the water, I believe that the Northwest Ordinance that deal about the Mississippi and the St. Lawrence River is a usurpation of powers by Congress.
It's a seizure.
It's a seizure of powers by Congress that they did not have.
Yeah.
They would have had to amend the Constitution called the Articles of Confederation in order to do that. And they did not do it.
That means that the founders who created the Constitution and also the Articles of Confederation are the same guys.
That's right.
Those same guys that created both of our constitutions had no intention of the federal government having ownership or authority over the waters that would be residing within the boundaries of every state they were going to create. They had no intention of doing so.
That's right. You're 100% correct. That proves it. It's proof right there. And then, like I said, when you go up to the what I'll call, to make it simplistic, our second Constitution, the one that we were all taught, if we were taught in civics a little bit about the Constitution, this is the one you're talking about. There's no place in there under commerce that mentions water. Not once. In the enumerated powers, I read them 5 times today just to double check. Am I missing the word water? No, it's not in there. I'm sorry, it's not in there.
Let me take just a few moments, and I just want to take, I'm going to point everybody to the board here. This is something that Dave and I had to work out. We had to go back through all the documentation to figure out at what point did the United States seize authority. They did it through a Supreme Court case out of Kentucky. It began in 1821. The Supreme Court in the U.S. history by Charles Warren laid out what they did. It was overturned in 1825 with a case called the Thomas Jefferson. Then it was overturned again in 1847 in Warren v. Clark. Warren v. Clark set the stage for what we have today, and it was a seizure of the water conducted by an inferior federal court out of Kentucky.
And when you
nationwide,
sure, the deal for the seizure of water was started in the unlawful action in the Northwest Ordinance. That's where it started. So we have followed this all the way back from 2022 back to 1777, folks. And I've looked at, oh my goodness, Ron and I have looked at dozens and dozens and dozens of Supreme Court cases. I've got them all. I've got a whole pile of them here, but we thought this would be enough for one video because there is so much explosive information here. Remember the dates, folks. Remember the dates. Look up the Articles of Confederation, print it out, look at it, and then look at the Northwest Ordinance. Print it out, read it. You'll come to the same conclusions, I'm sure, that Ron and I come with. And so the last thing is, like I told you, our little Constitution book here, my little Constitution book, you may be wondering, so I want to put this in before we close, Ron. You may be wondering about the Articles of Confederation. You may be wondering about that. Did that transfer in total to our Constitution? I want to point out Article 6, but unfortunately, I'm going to need my glasses to read it. But I want to point this out. All debts, this is Article 6, our Constitution as we know it today, says all debts contracted and engagements entered into before the adoption of this Constitution. This Constitution. They're talking about this. Shall be as valid against the United States under this Constitution as under the Confederation. See, all the stuff under the Confederation, it's right there. It uploads into this. This Constitution, the laws of the United States, which shall be made in pursuance thereof. This Constitution, that's this. And the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. And this is very important. And the judges in every state shall be bound thereby. That's very important.
Wow.
Anything in the Constitution or laws of any state to the contrary notwithstanding. So they're to be bound by any laws, what it says here, under the authority of the United States. But if it's contrary to the Constitution, and this is where Marbury versus Madison in 1803 got it. I know they did. They got it right here in Article 6, right there. That's where they got it. That said anything repugnant to the Constitution is null and void. Since Article 6 says that everything has to be honored in the Articles of Confederation.
Yep.
That means that this congressional law right here, the Northwest Ordinance, the land disposal, the section in there dealing with water. I'm sorry, folks, there is no constitutional authority for the Clean Water Act in the United States of America.
Yep.
Case closed. Case closed.
I don't know how you make it any clearer. The historical documentation and the precedent all align on this issue.
Yeah.
There's no deviation in the documents.
There's none. I mean, it's there. It's there. And I know what we've said on this video is so profound and so enormous of an informational dump that lawyers, judges, they'll be dumbfounded by this.
Yeah.
They'll be dumbfounded by it because I'm going to tell you, I know at least a dozen attorneys very personally, they don't have a clue about this.
Oh, I know.
They don't. I mean, I know they call themselves attorneys and they think they know the law. Hell, I asked one attorney that I know what the 4 sections of the First Amendment were. He got the first 3 right. But he didn't know that if you have a grievance against the government, you can actually take it to them.
Redress.
Yeah. So that's what that's what we're going to do. We're going to try and get some of this stuff out there to the public, and through my little case, we're going to try and expound on it and make people aware of what's really going on here.
Okay,
So,
well, Dave, thank you so much for this. This has been, wow. I mean, this has been an incredible interview. We've really gotten some brass tacks and, you know, got a lot of meatballs on our spaghetti here. But I want everybody to realize, and hopefully you guys go back on your own, look at the case law, look at the documentation, read it for yourselves, understand what's being said here, what was being said then. If you ever want a copy of my book, let me know. It's like I said, it's done being edited. I will have it up for sale soon. I'm going to self-publish.
That's great.
And yeah, it was a very successful editing session. The editor, I will tell you that the editor was very impressed. And this guy's edited a lot of work. He's edited a lot of high quality content, and he was very impressed with what was in that book.
Oh yeah,
I got some good conversations, and he told me, he says, "Hey, man, this is an excellent work."
Yeah, it is.
And really, Dave, you had a lot to do with me getting that book put together, because you knew enough about the subject where I could really rely on you for feedback. And I want to publicly thank you for your work and your assistance in bringing this to the people so that we could start getting clear boundaries of constitutional subject matter, clear boundaries in the states, clear boundaries of the government, put them back in their box, start getting control of the administrative state. This is huge, guys, and thank you for being here with the Western Land Policy Dojo with Dave and I today. And you guys have a great day.
Okay, Ron. Take care, man.